Everybody, and welcome to Good Tech, an ongoing discussion around ethics and technology. I'm Elizabeth Perry with Idka. As a reminder, this show is recorded and will be available on our YouTube channel on ubngo.com/goodtech and on any podcast channel you choose. If you're tuning in live today and have any questions or comments, you can dial the number on your screen and we'll do our best to get you in on the conversation. So we've discussed privacy on this show from a lot of different angles, GDPR here in Europe and other regulations worldwide. For more information about how regulations can affect you and your business, please check out our YouTube channel and you'll find lots of content there. So what about the business of privacy or privacy tech, businesses for whom privacy is core? Lots of players are cropping up, some of them bold enough to take on the giants, DuckDuckGo, Brave, Quant, Matomo, to name a few. Some of them have had enough of ad tech, the big tech giants who lobby for support for a business model which many say violates our rights to privacy. So there's a relatively new initiative taking place in the EU that we're going to talk about today. Very exciting. It's called Article 8. Article 8 is the world's first pro-privacy corporate lobby group, ensuring that pro-privacy business model has a voice in politics. So joining us today to tell us more is the leader of this initiative, world-renowned privacy advocate, speaker, and president of thinkprivacy.com. Please welcome Alexander Hanff. Alexander, you're looking mighty dapper today with your cookie jar.
Yep, I'm a little bit under the weather and my internet connection is not so grand as to be able to do video today. So you have an interesting cartoon that was drawn for me about 4 or 5 years ago, which I really enjoy.
Well, it certainly does illustrate who you are. And speaking of which, well, first off, thanks so much for joining us. I know how busy you are. You're very, very difficult to nail down most of the time because you're always doing something. Doing something good, though, I'm sure. We're going to talk about what you've been busy with. But first, let's have a little background on how you got started with privacy in the first place.
Oh, it's a long time ago now. So I'm a computer scientist and psychologist by trade. And I worked for a long time in the tech sector. And for me, technology was really something which empowered me and lifted me out of a very difficult childhood from a very difficult family background, and enabled me to excel and find something that I was good at and give me opportunities which, had I not discovered technology, I probably never would have had. And so for a long time, I worked in the technology sector, both in industry and in government, and had a real passion for it. And as time went on, I started to realize that the technologies that I loved were starting to be used in ways which I didn't feel were appropriate. So instead of being used to empower people and give people opportunity, they were being used to commoditize and control people. And this concerned me as a technologist and to be frank, as a geek. And I wanted to look at that more from an academic perspective and see if my suspicions were correct. And so I went back to university and studied the impact of technology on society as a sociologist, and did indeed confirm my concerns that these tools, these technologies, which had enabled me and empowered me in such strong ways, were now being used against us. And to quote Tim Cook, you know, our data is being weaponized against us with military precision. A statement he made at a conference in Brussels a couple of years ago. So around that time, I was just finishing my dissertation, and I got heavily involved in a campaign against an ad tech company who were using deep packet inspection in ISP networks. Deep packet inspection is a technology which allows you to look at the content of communications over IP networks, over the internet, and look at those content and then use that information to build behavioral profiles. So unless that data is encrypted, and even then through the use of man-in-the-middle attacks, they could still decrypt that data in many cases, your communications were completely exposed. And they use this to build behavioral profiles in order to sell advertising. And that to me didn't seem right. So I did a lot of research into the situation, into the legal aspects of that, and discovered that it was indeed illegal in the EU across many different laws, not just data protection law, but confidentiality communications and various other things. So I wrote a paper on it. I ran a grassroots campaign, and a $1 billion company ended up bankrupted. As a result of that, there was a big change to European law, the e-privacy directive, which is where the cookie picture comes from that you can see there, in 2009, when we introduced new clauses or amendments to the existing e-privacy directive to regulate the use of tracking technologies, not just cookies, but that's the one that gets the most attention, but tracking technologies generally. And then that led on to the development of GDPR. And as you know, I've been heavily involved in the development of the upcoming e-privacy regulation as well. So really, right, that's the background. I went from a tech background into policy background, right, and having a very wide perspective of the issues, both from a psychological perspective, sociological perspective, and a technological perspective. And now having been heavily involved in legal aspects as well, so developing law as an expert advisor to the European Union. So it's been a crazy 12 years.
Yeah. And it's kind of come full circle now. Well, it's everything is tech, right? I mean, tech is tech. Everybody's tech. Every company is technology company now, and it's hard for people out there. I think from a business perspective, to figure out how to do things in an ethical way, and we'll talk about that later. But first, I want to talk about Article 8, which is the exciting movement that's going on right now. Tell us about that. How did it begin, and what's the latest on it?
Again, I mean, that's an interesting situation. I worked for Privacy International for 3 years, heading up their privacy portfolio back in 2009 to 2012. And towards the end of that time, I started doing some work with companies who were focused on privacy, developing privacy enhancing products and services. And I did that continuously for almost a decade. And then last year, it became clear to me that when you go to a politician, you say to a politician in Brussels, look, we need to take privacy seriously. It's a human right. It's a fundamental right under the European Charter. And these giant US tech companies are exploiting these rights in ways which aren't compatible with law and are infringing on our human rights. That's a very difficult argument to push to politicians, because technically at the moment, I'm the only registered privacy lobbyist in Brussels. There are many other lobbyists who lobby on privacy as well, but I'm the only one who is literally dedicated just to privacy in Brussels. And I'm up against over 30,000 tech industry lobbyists. So I go to a politician, I say, human rights, human rights, human rights. And the tech industry go to politicians and say, economics, economics, economics. And we all know, which argument is going to bear the most weight with regards to those politicians. And it tends to be the economic argument. And then, as you know, a couple of years ago, Edward Snowden came onto the scene, and then we had the Cambridge Analytica scandal. And in between that phase, about a year before the big news broke on Cambridge Analytica, I'd become aware of it. I ran an event at the European Parliament in Brussels, and I noticed a big change in the event by the way I was presenting the situation. So instead of saying to the politicians, human rights, human rights, human rights, I said to the politicians in the room, you're all going to lose your job. And they said, what do you mean? I said, well, because the voters who would normally vote for you are now being manipulated by your opponents or by rogue states who want to have a right-wing movement through psychographic profiling through companies like Cambridge Analytica. So you're going to lose your job because they're no longer in control of the decisions that they're making. These aren't reasoned decisions anymore. They're based on emotional manipulation through psychographic profiling. And all of a sudden, the politicians started to listen. When it comes to something which is going to impact them directly, they became much more concerned. Now, I'm not saying all politicians are bad and self-interested. There are some very good politicians out there who've worked in this space for a long time and very diligently. But there are a lot of politicians who do take the economic interest more seriously, and when you can push a different opinion to them that this is going to have an impact on them directly, then they tend to listen more closely. And around the same time, I had several clients I've been working with for close to 10 years in some cases, who were working in the privacy space. And it occurred to me that despite the fact there are many industry groups and lobby groups in Brussels and in other cities around the world, they're all focused on lobbying on behalf of the companies who are exploiting our fundamental rights in ways which we would consider as not lawful. But there's this emerging market of tech companies and services who are focused on providing privacy as a unique selling point, who didn't have any representation. They weren't spending any money on lobbying. Several of them were my clients. So I thought, well, instead of working with each of these individually and going to Brussels and lobbying for one of them at a time, it makes more sense to build an industry group the same way as other industry groups exist, but this time for the companies who are focused on delivering privacy as opposed to those who are focused on exploiting it. By doing that, you can then present a different business case to politicians, which is based on economics, because these companies are all sustainable businesses making money from sustaining privacy as opposed to exploiting it. So you end up with this counter argument against the big tech companies who say, well, we can't make money if we don't exploit privacy or don't exploit personal data. When we have these strong examples of companies in the EU and elsewhere who are doing exactly that, and who are increasing their revenues and turnovers on a year-by-year basis, as a clear illustration that, no, actually you can have a viable business with privacy as a fundamental and unique aspect of that business. So that's where Article 8 was born, and Article 8 was really a play on words. So Article 8 under the European Convention on Human Rights is the right to privacy. Article 8 under the Charter of Fundamental Rights is the right to data protection, and of course to articulate something, to speak on behalf of Article 8. So that's where the Article 8 name came from. It was a combination of data protection, privacy, and representation for those companies within that specific sector of industry.
Right. So just let's back up 1 second and make it clear to our audience what we're talking about when we're talking about like how your data is being harvested and what is actually happening out there that's wrong is psychographic profiling, for example, because you mentioned that, and I think that's important for the newbies in the room.
Yeah, so I give a lot of speeches. I'm a faculty member at Singularity University in Silicon Valley. I give a lot of speeches each year on data ethics. And two of the issues I cover under that are the Hawthorne effect, which is a psychological phenomenon which states that or explains that if people know that they're being observed, they change their behavior. And this is common sense for most of us, particularly those of us with children. When we tell a child not to do something, they don't do it until we're not looking, and then they change their behavior. And this is a well-known phenomenon in psychology, the Hawthorne effect. It's well established, particularly in experimental psychology. One of the things that you need to try and deal with is participant observation, making sure that the behavior isn't changed as a result of them being observed. So the Hawthorne effect. And a good example of this in the modern world, if you've seen Black Mirror, the Nosebleed show where they're scoring each other on the phones, the social credit system, and their interactions within the social world are based on what their social credit score is. And then if you look at China and what China have done, and they basically, it's almost as if they saw that Black Mirror episode and said, hold my beer, and then introduced the social credit system in China. And what this does is it's a mechanism to control the population, because if people know they're being watched, they change their behavior. So they change the people that they associate with, they change the things they say, they change the places they go, et cetera, et cetera. And all these things we consider as fundamental freedoms and fundamental human rights in Europe and elsewhere in the world. Freedom of movement, freedom of association, freedom of speech, et cetera, et cetera. When you're being constantly observed, you lose those freedoms. So you lose agency and you lose self-determination, you lose autonomy. You become almost the product of somebody else's concern. Yeah, you become almost like a robot. So you have that constant observation side of things, which changes behavior and has a profound impact on the self and on society as a whole. And then you have what Cambridge Analytica was doing, which was psychographic profiling, which is nudging people based on their psychological profile in ways which will manipulate their emotions to react in a specific way. So if you think about how this was used in elections, one of the big ways this was used was immigration. So a lot of people are people are generally quite reasonable people and don't think badly of others and aren't racist and all these other things. But there are certain triggers with certain types of psychology that will lead people to behave irrationally. Yeah. So if you're constantly being told that immigrants are going to steal your jobs, they're going to rape your children, they're going to increase crime and so on and so forth, the more of these messages you see, the more your subconscious is going to start to believe that immigrants are bad. And whereas rationally, you probably wouldn't think that, because people are people and people are people. And most of us don't judge people based on the color of the skin or where they come from. So this is an example of psychographic profiling. The way it works, and this was developed by psychologists in the early 20th century as a marketing tool. And the way it works is you create a profile of somebody's psychology by looking at the things, how they respond to certain questions and stimuli. And then once you have that information, once you have that profile, you can then target specific emotional responses by either through fear or other behaviors which would make people behave in an emotional way, a non-rational way. And obviously, rational thought and rational decisions are decisions that we want to make, because they tend to be ones that we've thought through. They tend to be ones which are quite sensible, and the outcome is going to be balanced. Some irrational decisions we take for granted every day. People fall in love and people like ice cream and things like this. But generally, we try not to be irrational. We try to make decisions based on rationality, based on our mind rather than our heart and our feelings. Because when we make irrational decisions, they're obviously not logical in many cases. And, we've all heard the expression knee-jerk reaction and things like that. These are irrational responses. So by nudging people from one point to another point, and bearing in mind, I call these micro nudges because it's generally the result of many dozens or even hundreds of messages over an extended period of time, which makes it very difficult to detect. Yeah. Which is why detecting these things on social media has been so difficult. There's prolonged offensive on people's psychosis or the psychology in order to make them go from this rational position to this irrational position. We call that psychographic that's as a result of psychographic profiling. Cambridge Analytica weaponized this in a particularly effective way. Social media became a very effective tool for this, because the ability to insert messages into people's day-to-day life became much easier. Right. A lot of people spend immense amounts of time on social media, reading a lot of information, and inserting things into that information stream has become very easy, because all of these platforms have sponsored content, because that's how they raise their revenue, through advertising and sponsored content. So we started to see with Cambridge Analytica that many millions of these messages were being pushed out to certain demographic groups or certain areas of the population to impact democratic decision making, or to impact the elections that we were seeing in the US and the UK, referendums like the Brexit referendum in the UK, for example. And it was incredibly effective. And the danger that we have there is, so on the one side, we've got this Hawthorne effect, if you like, this observation phenomenon that we have where people change their behavior. So that erodes agency and self-determination and autonomy. And then the other side, we have this manipulation going on from in this case, it's Cambridge Analytica, but exactly the same thing is happening in ad tech effectively. It's this manipulation of the psyche, which again is removing agency and removing self-determination and the ability to make decisions and choices in a rational way. And we eventually end up eroding the self, who we are. Are we people anymore? Do we have the freedom of choice and thought anymore? Or are we simply the product of somebody else's intent? And that to me is not just from a technical perspective as a geek, but as a human being and as a sociologist and a psychologist is an incredibly frightening thing to observe. Not just because of the impact it has to us right now in the current time and space that we exist in, but future generations as well. Because the more we normalize this, the more this becomes normal and it's happening on a day-to-day basis, the less control and the less choices our children, our grandchildren, our great-grandchildren, future generations are going to have. So as a species, we become even more and more isolated. We lose individuality. We lose all these things that make us what we are as a species. And that has a profound impact on society. It has a profound impact on democracy. It also has, incidentally, and one thing that the tech industry don't seem to understand, it has a profound impact on innovation as well. Because what does innovation rely on? Innovation relies on us thinking outside of the box. We see a problem and we try and find a solution.
Yeah, exactly. And freedom to think for ourselves and think differently.
But if everything we do is being driven and manipulated by some other entity, all those freedoms disappear. So innovation becomes stagnant. We end up in a situation where we no longer evolve, not just as a species, but as a society and as this complex organism that society is. So all these things that the ad tech companies and these giant technology companies strive on innovation are actually self-defeatist, because eventually if we keep going down this path, we will lose that ability to innovate because we will all be controlled and manipulated. So it's a really very serious situation, one I take very passionately about.
Yeah, and I remember when we were talking on the debut show, you went into that, but I think and correct me if I'm wrong, but I think the urgency here, at least as it relates to the tech business that we're kind of talking about today, ad tech, is that innovation, that if we stop innovating, we die.
Yeah, I mean, certainly our intellectual growth suffers significantly. And with that, our social growth suffers significantly.
Yeah.
And look at what's happening at the moment. We have the coronavirus, okay, which is causing massive problems around the world. It's a global pandemic. We will overcome the coronavirus, and we'll overcome the coronavirus because we're able to innovate. What happens 100 years down the road when we're all automatons controlled by somebody else's manipulation, and we come across the next version of the coronavirus? How do we tackle that then? How do we handle that then? We don't, or our ability to do so is significantly diminished. Yeah.
Well, I want to give you a chance to talk about how Article 8 is sort of tackling some of this problem. The title of today's show is Up Against Giants, right? How is Article 8 tackling this problem?
Well, I mean, first and foremost, we're the only pro-privacy lobbying group, to my knowledge, currently in the world. And there may be other ones out there that I don't know, but I don't know of any currently other than Article 8. And the idea behind it is, as you mentioned earlier, is to give a voice politically to those companies who are working under the umbrella of strong data ethics, trying to provide privacy enhancing products and services. And it's a growing market. Every year we see a significant number of new players coming into the space. Idka, the company that you work for, try and do exactly the same thing with their technology as an alternative to Facebook and various other social networks. And the same can be said for various privacy search engines like Ecosia and Startpage and Quant, which you mentioned earlier. Secure email services. There's a whole host of new privacy tech services which are been coming online now for really about the last 4 or 5 years. Some of them have been going a lot longer. Startpage in the Netherlands have been going for about 12 or 13 years now. But the real insurgence of these technologies has happened since the Edward Snowden revelations back in about 2015, 2016. And they need representation, just as all the other competitors in this market have their industry groups. So should the companies who are working in the pro-privacy space, because if they, we're often critical of politicians in not doing what we think they should do. But we have to understand that politicians make their decisions based on the information they have available. So if the only information they have is coming in one ear from the tech giants and and the advertising industry and the online publishers, etc., saying we need to do this because it's good for the economy, and we'll lose thousands of jobs if we can't do this, and so on and so forth. If that's the only voice that they're hearing, that's the only information they can act on. So if the pro-privacy industry don't have a voice in this argument or in this space, then their message is never going to be heard. And if their message is never heard, then the politicians can never act on it. They can never make decisions based on that information because they don't have it. So the idea behind Article 8 is to provide that counter voice to the tech giants of the world who are seeking to undermine our way of life, our democracy, our fundamental rights. And those companies who are trying to compete with them on the opposite premise. So it's really important that there's, just as important to have equality in any other aspect of our society, having equality in political lobbying and having that equal voice is just as important.
Now, you write a letter to, you write a letter along when you go onto your website, which is, by the way, www.article8.com, which is without the E, right?
Yeah.
And you can find all the information in there, but in your letter, you note that, quote, the Council of the EU has repeatedly delayed progress, calling for the removal of critical protections for EU citizens and businesses. Can you tell us what protections are being threatened?
So as you know, in 2016, we passed a law in the EU called GDPR, General Data Protection Regulation. And that replaced an old piece of legislation called the Data Protection Directive, which was introduced in 1995. So first of all, it's important to understand the difference between a directive and a regulation under European law. A directive is secondary law. So what that means is it's a general piece of law which member states must apply and implement at their own level. And the problem with that is every member state interprets the directive in a different way. Yeah, so when it came to the Data Protection Directive, we had lots of different interpretations of what should be done with regards to data protection in the EU. So we seek to clarify that with the GDPR, which is a regulation, and a regulation is primary legislation and must be implemented in each member state in exactly the same way. There's no room for interpretation with certain caveats. So we have what we call derogations, which allow certain flexibility on a few issues within the GDPR. But generally speaking, it's implemented equally across all member states. And the reason for that is to harmonize the law and to ensure that free flow of information within the EU happens in a way which is appropriate, but that there are certain responsibilities on an organization for having that benefit. Makes it much easier. It facilitates the free flow of personal data in the EU. Because otherwise you have to comply with 27 different laws. It used to be 28, but as we know, the UK have now left. And a corresponding piece of legislation to the Data Protection Directive was the e-Privacy Directive. And this was the piece of law that I worked very hard to change in 2008, 2009, which I mentioned earlier on, which implemented these changes to how we can use tracking technologies. And when GDPR came into effect, we needed to upgrade the e-privacy directive and make that a piece of primary legislation, make that into a regulation, modernize it, close some of the loopholes, because we had exactly the same issue with the e-privacy directive as we had with the old data protection directive, different interpretations and implementations across member states, which made it very difficult to clarify certain aspects of law, such as should we have opt-in for cookies or should we have opt-out for cookies? Is it okay to have implied consent for direct marketing, or must we have explicit consent? These things were heavily debated, and as a result, there was very little enforcement action, because as we know, the companies who are using these technologies are global, but the law which was governing it was fragmented across lots of different countries. So it's very difficult to enforce those laws. So we introduced back in, I think it was 2017, it seems so long ago now, the European Commission introduced a new file called the e-privacy regulation, or a draft e-privacy regulation, which was intended to do the same thing for the e-privacy directive as GDPR did for the data protection directive, modernize it, close the loopholes, and have this harmonizing effect across the EU. The difference between the privacy regulation and the GDPR is the GDPR is focused specifically on personal data. So only data which is considered as personal data and the processing of that data is covered under GDPR. E-privacy has a much broader scope and is focused on anything which can be considered as communications data, irrespective of whether or not it's personal data. And it has an elevated position over GDPR. We call it lex specialis, which means that the conditions which are set within the e-privacy regulation take precedent over the GDPR. Yeah. So in the case of the privacy regulation, we worked, the European Commission introduced a draft at the beginning of 2000, I think it was 2017. I forget, it's been a long time now. I was involved very early on in that with the European Parliament as an advisor to Marty Lauriston and her team. She was the rapporteur for the European Parliament on the e-privacy regulation. And the way law works in the EU is, first of all, the European Commission introduced a proposal, and then you have the European Parliament and you have the Council of the EU, or the Council of Ministers. The Council of Ministers are permanent representatives from each member state, and they create a draft, and the European Parliament are obviously elected MEPs from each member state, and they create a draft. So you end up essentially with three different documents. You have the original proposal by the Commission, you have a document which is an amendment of that by the European Parliament, things that they want to change or things that they want to add, and then you have the Council of the EU or the Council of Ministers draft with the things that they want to change or the things that they want to add. And as is often the case, and was certainly the case with the GDPR and has seemed to be the case with the e-privacy regulation, MEPs tend to do a pretty good job. You know, they're elected officials. They have quite a lot to lose if they don't regard the instructions of their citizens in a way which is particularly useful for them. So we tend to find, and we saw this with GDPR as well, that when we get the European Parliament draft of a specific piece of legislation that's been introduced by the Commission, it tends to be quite protective of fundamental rights. We saw that with GDPR. We've seen it again with the e-privacy regulation. So we worked really hard, and I can attest to this because I was there, sat on the floor with thousands of pieces of paper around me and the rest of the drafting team, figuring out how we can overcome some of these issues that we'd seen with the previous directive. We worked for many, many, many months on coming up with what we could see was something which would align well with the GDPR and also be protective of fundamental rights and achieve the same intent as the original directive. And one of the important things to take into account is when we introduced the regulation, it was important that it didn't weaken the existing rights. It didn't weaken existing law, because that would be contrary to the purpose of the legislation in the first place. The problem then is the Council of Ministers, and bearing in mind that the presidency of the EU changes every 6 months. So every 6 months we have a new presidency, which is a different member state. And
Right.
every member state takes control of existing files each time they come into a presidency. So we've had multiple different drafts which have been led by multiple different presidencies since the European Parliament draft was passed by vote back in 2000. I think it was late 2017, October 2017, I think it was. And each of these drafts that we see from the Council of Ministers has been increasingly worse and worse and worse and watered down and removed entire clauses or articles, as we call them, from the original proposal from the European Commission and from the amendments or the wishes of the European Parliament. Some of those are incredibly critical clauses, such as Article 10 in the e-privacy regulation, which is focused on ensuring privacy by design as a requirement of law. So making sure that when we develop new technologies and new services and new platforms, that privacy is baked in from the very beginning. It's not something which is ignored completely or added on as an afterthought. And this is very important because one of the requirements of the GDPR is that we have data protection by design and by default. So the correspondence to that, or the correlation to that within the privacy regulation, will be privacy by design and by default. And one of the other areas which has been a controversial topic has been on the use of how we access online services and products. So one of the risks we face currently, and one of the things I speak about frequently, is if we start commoditizing personal data or privacy, if we start using that as a currency, then you end up with a split class system where people who have money, who can afford to pay for expensive prices for accessing online products and services, they can have privacy because they don't have to sell their data or their privacy in order to access these services. That's not their currency. Their currency is money. But those people, which is the majority of people who use the internet, who don't necessarily have high disposable incomes, end up losing their privacy if they want to engage in digital society, to want to be a part of this digital world that has now become so integral to all of our lives. So you end up with this privacy class system. So the risk of commoditizing fundamental rights is exactly that. You end up with those who have money, therefore they have human rights. Those who don't have money don't have human rights. And it's something that we really seriously need to avoid. And one of the things that we're seeing, or were seeing a growing trend, was particularly with regards to the use of mobile applications and online services and websites, is requiring people to consent to the tracking of their online behavior in order to access the service. So, I mean, the most obvious examples of this are companies like Google, Facebook, Twitter, Microsoft, etc., where they provide you these enticing free products like the Facebook social network, or Google's voice over IP services, or Gmail, etc., etc. And then, but their currency for that is your privacy, your data, which they use not just to sell to others, but to manipulate you in ways we talked about before, psychographics, etc. So it's not just an economic argument; it's a sociological argument as well. And there was a clause within the privacy regulation which forbid this. We made it, and this corresponds with the GDPR as well. The definition of consent in GDPR is that it must be freely given. And in order for consent to be freely given, there can be no detriment to not consenting. Yeah. So you can't say to somebody, you can't use my service if you don't consent to me processing your personal data, because that would be a detriment, which creates a duress situation, a situation where there's an imbalance of power. Yeah. In order to engage in digital society, you have to consent to unlawful, what is effectively unlawful processing of your data. And just as we can't contract away other human rights, such as the right to life, we can't say to somebody, if I use your service, you have the right to kill me. Yeah, you can't contract away other human rights either, like the right to privacy and the right to data protection. So we made sure that the privacy regulation, which draws its definition of consent from the GDPR, had specific and explicit language in it to prevent or to forbid the use of what we call tracking walls. These big notices that appear on websites obscuring your use of the website until you consent to the use of your private and personal communications data. And that has been removed multiple times in various drafts from the Council of the EU as well. And various other things such as data retention have been added in, which was ruled unlawful by the European Court back in 2015, I believe it was. Other areas with regards to confidentiality communications, unsolicited communications, etc. So we're seeing, and this is largely down, and again, the reason why I started Article 8 was to provide this equal lobbying voice. This is largely down to lobbying. The Council of Ministers are very susceptible to lobbying. And as a result of that, they tend to echo the wishes of industry. And in GDPR, it was a huge scandal. There was a website set up called LobbyPlag during GDPR, which tracked amendments to the GDPR being made by the council. And in many cases, they were simply cut and pasting documents which had been provided to them by industry, which is obviously a problem. And this happened hundreds of thousands of times. This wasn't just an every now and again situation. The GDPR was literally being rewritten by those it was supposed to govern.
So what was interesting for me, because I read the whole thing and I find it fascinating that it's not just a mirror. What you're proposing is not just a mirror of the privacy directive, but it's actually asking for more than that. But one sorry, I'm going to back up a second.
No, feel free.
You said important for that it's important for EU businesses who are currently competing in an unfair market against global technology giants who blatantly defy the spirit of the law due to loopholes created by fragmentation across member states.
Yeah.
What are the loopholes exactly?
So as I said before, when we had with the previous directive, because it was implemented based on different interpretations by different member states, a company could what we call forum shop. Yeah, so an organization, a global organization, would set up their headquarters in one country where there was a very light touch to the regulation. So when an offence occurred in another country, because of the way European law works, it's based on the established office or where a company is established within the EU, depends on how that law is enforced. Yeah. So if you have a country which has interpreted and implemented a directive in a particular weak way, or even if they've implemented it in the way it should have been, but the actual enforcement of that is incredibly weak, then that creates loopholes, because then a company simply sets up its headquarters there and there's effectively no enforcement of the regulation or the law. Yeah. So by having a regulation, we harmonize that across member states, so there's no room for maneuverability or interpretation, and effectively, as it's supposed to be in theory, each member state enforces law equally.
Yeah, I get it now. But let's go through some of the bullet points here on your actual proposal, or whatever you're calling it. The first one is a ban on tracking walls, which you just discussed, which is fascinating as well, because it should be privacy by default, right?
Yeah. Which is now backed up by case law in the Planet 49 ruling from
I'm
October
sorry,
1st
say again?
This year, which is now backed up by case law from the Planet 49 ruling and from the Court of Justice of the European Union back in October, which stated that that you can't have preconditioned or pre-opted in checkboxes. It must be an explicit action, which is again supported by legislation, but has been widely ignored from the aspect of it being interpreted and implemented in different ways across different member states.
Right. The next one was free informed consent is the only legal ground to process communications data due to their sensitive nature, which we also kind of went over. Privacy by design.
Well, this one you just mentioned is actually particularly important, because the latest draft, as you perhaps know, the Croatian government or the current presidency of the EU, they released a draft, I think about 10 days ago now, where they introduced legitimate interest as a legal basis for processing communications data under the privacy regulation. And this is interesting for a number of reasons. Under GDPR, there are 6 legal bases for processing personal data. So you have consent, you have public interest, vital interest, contract, legal obligation, and legitimate interest. Okay, it's been determined some time ago, and this has been reiterated by the European Data Protection Supervisor, the European Data Protection Board, the European Commission, the European Parliament, that because communications data is so sensitive, the only legal basis that we can really use for processing that data is consent, unless it's technically required to process that data in order to provide the service that's been requested. Yeah. So if you want to make a phone call, because this will be covered under the privacy regulation, there's certain data that needs to be processed by the carrier in order to be able to deliver that service to you. So they need to be able to know what your phone number is or where your terminal is, yeah, and the where the person you're trying to call is, and what their phone number is, in order to connect those 2 devices to make that call. So that would be okay. That doesn't require consent because it's technically required in order to provide the service that you've requested. If you were visiting a web page, and we all have different devices with different screen resolutions. So say, for example, you're visiting a web page on a mobile phone in portrait mode, the layout of that page, in order to be usable and user-friendly, is going to look different perhaps to the layout of a page that you would see on your main desktop computer screen or a tablet in landscape mode, because the aspect ratio of the 2 mediums is different. So you lay out the UI in a different way to make it more accessible and more usable. So the technology which is used to do that would be okay, because it's required in order to provide the service. If you have certain language preferences, yeah, so if a website sets a cookie to remember your language preference, it's something you've asked them to do because you want to have the content displayed in your language. Or that's fine. It doesn't require consent. It's considered strictly necessary. If you want to monetize your website by tracking people, having tracking technologies and adverts on your website is not technically required for somebody to be able to read the content in your website. It may be desirable to you as a business model, as an economic model, but it doesn't meet the requirements of being strictly necessary to provide service to the end user. So this is where we need consent. And the current presidency, the Croatians, have introduced this legitimate interest, which is something that we've said for the last 3 years. The European Parliament will never accept it. They've stated on the record that legitimate interest cannot be a legal basis in the e-privacy regulation. So this issue that you mentioned, the second one on the bulleted list there, about consent, this is very important and is a very current threat to the existing draft.
Yeah, and we did discuss privacy by design, which was the next point.
Yeah.
I think, we got there, and by default in hardware and software.
Yeah. So and this is an important issue as well, because many people think, one of the problems why we have a failure with regards to protecting communications online under the e-privacy directive is this misunderstanding that the addition that was made to the directive as a result of my work back in 2009 with regards to tracking technology is only focused on cookies. And there's a what we call a recital in the particular piece of law which amended the e-privacy directive, recital 66 of the telecoms reform package, which stated that the use of browser settings to indicate whether or not an end user accepts these technologies may be a suitable solution. It doesn't say it is a suitable solution, it says it may be. And of course, most browsers have the ability to block cookies, but in most browsers it's turned off by default, although Safari and Mozilla Firefox now have third-party cookies disabled by default. But that's taken a long time to happen. Safari have done it for some time, but Firefox only did it, I think, last year. So that's taken a long time to happen. And we have other things like Do Not Track, which is ignored by websites pretty much globally. There are very few websites adhere to the standard of Do Not Track. But it doesn't deal with any other issues, such as JavaScript files, which are loaded onto your device, other tracking technologies, such as tracking pixels and beacons, which are stored in web pages or in emails, which are sent by telemarketing, direct marketing companies, etc., all used to track whether or not you've read the email, whether you opened the email, etc., etc. So the technology which was available in web browsers to block cookies only covered a fraction of the problem that we were facing with regards to online tracking and behavioral profiling, and didn't meet the requirements of law and never can meet the requirements of law. So the reason why we introduced Article 10 into the e-privacy regulation draft was to ensure that all software, that includes operating systems, not just the browsers that we use on them. I'm sure you know that Microsoft Windows, for example, sends massive amounts of telemetry data back to Microsoft. Microsoft have been pulled up on this by multiple regulators across the EU as not being compliant with the law. So it's not just our web browsers and our websites. Pretty much most of the software that we use nowadays is engaged in some sort of infringement on our private domain, on our private space. And furthermore, the hardware that we use as well. So Google, for example, create Android. They also create certain hardware devices, such as their tablets that they create and the cell phones that they create. You have Apple create their own hardware as well. Microsoft create their own hardware. And many of the sensors which are in these hardware and the software or the operating systems which run these hardware are sending data back to these parties as well. And we see the same thing with Huawei in China and Samsung and various other manufacturers of these devices, all sending telemetry data back to them. So we felt it was really important to address this huge gaping hole in the understanding of what we consider to be tracking technologies and technologies which were infringing on our fundamental right to privacy, and that it wasn't just cookies. And it annoys me to no end to hear people refer to the changes to the privacy sector as the cookie directive, because it was never about cookies. Cookies were a small part of a much wider problem.
Right.
And really, there was a lot of sleight of hand by the ad tech industry to really put the focus on cookies so they could develop alternative technologies. So, for example,
Right.
Google had just been exposed just yesterday, I believe it was, in an article by the Register, as having a special header, a little piece of information which is sent with every single browser request from Google Chrome, which has specific information about the individual use of that particular Chrome browser. So information about the device it's being sent from, etc., which can be used to track people. Other things like Google Fonts. If you inspect the code on many websites out there, they use Google Fonts, where they hot link a font from Google servers directly into their website. Of course, the problem there is every single time you load the web page, if you haven't got the font cached, your device connects to Google servers and downloads the font. So from Google's perspective, this is great. They provide these fonts for free because they can effectively see pretty much every website that you visit and use that to build a behavioral profile. They don't need cookies. They can just, their server logs alone will tell them that your IP address visited this website because you downloaded a font from their server, and visited this website because you downloaded a font from their server. So right. it was never about just cookies. It was about the entire ecosystem of tracking technologies. And many of the things that people use for free, such as JavaScript libraries, which have been developed by companies like Google and Facebook, etc., like buttons on web pages and social media, ways that people can interact, which directly connect your device as an end user to these third-party servers, and you never know about it unless you're a technical person. You have no knowledge that this information is being shared in this way with these third parties. You have no real relationship with these third parties in many cases. The case of Facebook shadow profiles is a very strong illustration of that, where people who don't even have a Facebook account, Facebook have masses of information about them because of these shadow profiles that they create from things like buttons and Facebook Pixel. So it's not just about cookies, it's about all of these technologies at the software and the hardware level, which enable and facilitate the tracking and profiling of individuals' behavior and online activities, and increasingly offline activities as well.
Right. Well, guess what? We are out of time, which is just a terrible thing, because there's so much more to cover.
You should know by now to do a 2 hour.
I should know by now, but I just can't get enough of you, Alexander.
I do have a habit of waffling on, I should say.
But it's all just fascinating. And thank you so much for being with us today and for the effort. And we will, if you don't mind, I'd like to keep in touch about this Article 8. And if you want to reach Alexander in the audience, he can be reached at what you can see below his picture there. The Twitter is Alexander Hanff, and the other is Think Privacy, correct? At Think Privacy.
Yeah.
And Article 8, again, article8.com, read about it. How do people get involved, Alexander?
I would urge any company, startup or mature company who are focused on developing privacy enhancing technologies and services, you need a voice, and the cost of lobbying independently is very expensive. You need to have people going to Brussels or going to various member states, having meetings. The resources it takes is exhausting, and also you're isolating yourself in that situation. You don't have a stronger voice. So if you're a company working in this space, consider joining Article 8, because together we're much stronger than as individuals, which is the entire reason why I started the lobby group in the first place, was to have that joint representation, to have that much stronger voice. And politicians are far more likely to listen to a group which is representational of multiple bodies than a single entity. So, I would urge people to join and, to help really raise the focus and raise the bar on these issues, not just because it's the right thing to do, but because it helps them as well. I mean, they're competing in a market which is completely uneven. There's an imbalance of power. If they're producing a product or service which in any way whatsoever competes with something that Google or Facebook are offering, If Google and Facebook are not obeying those laws, and you are, then A, you have higher costs. B, you have a much bigger hurdle to get to market. And
Mm-hmm.
C, you're not competing on an even playing field. It's not a level playing field.
Right.
So
Well, Idka is
it's
very proud to be a member, and so
yes, and you
I
have been from the beginning.
second the motion.
So I think it's just very important to be represented. I'm I'm not some rich lawyer or law firm. I'm a regular guy sat in my small house in the middle of the forest in Sweden, doing everything I can to try and deal with these issues, both as a consumer advocate, as a person, but also as somebody who wants to see companies who are genuinely striving to build ethical products and services to succeed and to have an entry to
Right.
market which is not going to be restricted by this massive voice from the global tech industry who are simply not obeying the law.
We're going to be kicked out. So we need to close today. Alexander, thank you so much again. Always a pleasure, a
You're
learning
very welcome.
experience.
It's always a pleasure
And
for me as well.
yeah, and we'll see you again soon. To our audience, thanks for tuning in. If you have any questions for Alexander or me, connect with us on Idka. That's www.idka.com. Join the open group Privacy 2020 for news and discussion. If you like what you hear, please share the love. We're on Twitter at IdkaAB, LinkedIn, Instagram, and don't forget to hit the subscribe button if you're on YouTube. Have a great morning, afternoon, or evening, wherever you are in the world, and we'll see you again on the next Good Tech.
The doggy